the bail system fair in California, and was not fair. I mean, there is rules that are supposed to apply to everybody equally. There is specific alternatives that the court is supposed to look at to allow someone to remain out of custody, have the presumption of innocence, and fight their case. It's very difficult to fight a case and meet with your defense counsel when you're in custody. So we're disappointed about that, and what we're going to do about it is we're going to go to the appellate court. That's where there's a lot of action right now on the bail system in the appellate court, and we are confident that if an appellate court reviews all of the record, there's a lot of the record that you guys don't have as the media because it's not appropriate in the public domain, considering the nature of the case. Well, the appellate court's going to get to see it, and we are confident when the appellate court sees all the evidence that we have that they will remand the case back for appropriate bail setting.
To keep in mind, a bail hearing is a one-sided event, and it was extraordinarily one-sided for this bail hearing. None of the defense evidence was allowed to be heard. None of the defense witnesses were allowed to take the stand. When you have a situation like this with a concept under a bail hearing that all of the evidence and all of the allegations are to be presumed true by the judge, it's extraordinarily difficult to get fairness. That's why we have appellate courts. I've won in the appellate court this issue before, and I intend to win this issue for what happened today. We know, because we have done internal investigation, that we at 1,000% know that our theory and our belief is true. We have the witnesses, we have the evidence. We lodged it with the court after the hearing because that's when the court would accept it. So you think to yourself whether this was a completely balanced process when one side is allowed to call everything and the other side's allowed to call nothing, and I'll let you draw your own conclusions. But this is one round in what's going to be a long fight, and we are going to fight because we know what the truth is, and we're going to prove it.
What exactly are you, so why wouldn't you go to the appellate court after this case is wrapped up? Why go now?
Because we don't have the time to go after it's wrapped up. We want our client out of custody. We want him to be treated fairly. It's hard for me to understand how there can be somebody with 600 plus alleged victims and they get bail, and our client with one piece of evidence that was described or given information about, one piece out of all of this tip of the iceberg, one piece of evidence in which the expert himself said that he could not tell you whether the person in the video was an adult or a minor. And that is so flimsy, it's just preposterous, the ruling that we are